Thank you, Madam Clerk. I think I'm going to skip over the introductions and introductory remarks that seemed adequate this morning, so we'll just press on. We have one case on the docket, so if you'll call that case, Madam Clerk.
Darius, Markee, Alston versus State of Tennessee.
"20 minutes per side. That was the most important part of what I said this morning. You probably already knew that.
Can I reserve 5 minutes for rebuttal, Your Honor?
5 minutes?
Yes, sir.
Yes, sir.
May it please the court, my name is Jacob Vanson, and I represent the appellant, Darius Markee Alston, in this matter. This is an appeal of the trial court's denial of a writ of error quorum nobis based on procedural grounds. The trial court held that because the writ of error quorum nobis was filed more than 1 year after the final judgment in the case, that my client was precluded from writ of error quorum nobis relief because of the statute of limitations that is applicable. We argued before the trial court, and we argue again here today, that my client is entitled to equitable due process tolling for 2 reasons. The first reason is his mental incompetency prevented him from being able to realize his legal options. And then the second one, that's a 2-part test. Either one, not able to understand your legal options, or 2, unable to make a rational choice amongst those legal options. So that's one grounds is his incompetency. The other grounds is effective attorney abandonment, which can also constitute grounds for equitable tolling of the statute of limitations. Now, I want to accentuate kind of what a perfect storm of equitable tolling we have here. And I want to kind of lay out the timeline a little bit. I don't normally try to go through facts at oral argument, but I think in this case the facts are particularly important. And the particularly important facts are dated from the time Mr. Alston was convicted in February of 2018 until the time that he actually filed, well, I filed on his behalf, the petition.
You were appointed, correct?
I was appointed by this court to represent him on the appeal of post-conviction proceedings. So he had other counsel.
Thank you. Thank you
Oh.
for doing that.
But in this case, I'm representing him pro bono. I wasn't appointed because it's kind of collateral to the post-conviction proceedings that happened. But so in February 2018, he's convicted in Lauderdale County. He goes immediately to the TDOC custody. And then it's there in the record, his mental health problems that he had before coming into TDOC custody, paranoid schizophrenia. He's had psychosis. It's documented there in the record. There may be some other diagnoses, too, that are there in the record that I'm not remembering off the top of my head. But the 2 key are the paranoid schizophrenia and the psychosis.
Did he plead guilty in his federal case prior to going into TDOC custody? Or give me the timeline for when he had the mental evaluation in federal court?
So I've never been able to really figure out when exactly he had the mental health evaluation in federal court. I say I've never been able to figure it out. I can't recall off the top of my head. I remember being surprised at how far in advance of the trial it was, because, and I want to say this is based on my recollection of the record, which I don't have 100% right now, so I don't want to, I'm not necessarily speaking gospel truth at this exact moment. But so he was either under federal indictment or pending some type of federal charge at the time that he was indicted for this crime. And that case, the federal case, got resolved first before he was tried for this crime. And he did plead guilty in federal court. And I can't remember, I apologize.
Well, we know that it would have been prior to entry of the guilty plea that he would have been evaluated in federal court.
Right, yeah.
And that was referred to either in your brief or the state's brief. There was just not a It was just a reference, and I wanted to get some clarity on when that happened for purposes of your, the first prong of what you're relying on for equitable tolling being his, I guess, intellectual disability, for lack of a better word.
I do know also that he was ordered by the trial court, or really his attorney, effectively in the state, were ordered by the trial court to have him undergo a mental competency evaluation, for Tennessee purposes, for the state case. That was just never done.
I understand, but that attorney made reference to the federal evaluation at some point, and he also testified, I think, at the post-conviction hearing, one of the hearings, I can't remember which one, that your client was fairly lucid, and he was on the medication as a result of whatever the testing was in federal court, and that he appeared to respond to that medication well. Is that
Right,
correct?
I believe that is what he testified to. The time period, though, that we feel is applicable for this appeal is from the time he was convicted until the time he filed his post-conviction relief, no, I keep saying post-conviction, sorry, his writ of error quorum nobis petition, because that's the time period during which the statute of limitations was running, and that's the time period that the quorum nobis court in this case considered when trying to determine whether or not he was mentally incompetent or not. And during that time period, the records clearly show that he was suffering from paranoid schizophrenia and psychosis.
But he was also filing notices of appeal in his post-conviction matter pro se. That's what the error quorum nobis court relied upon, the various pro se filings that your client did file.
All of which, on their face, say that they are done with the assistance of legal aid. And
So why not have legal aid assist him with the filing of his writ of error quorum nobis, if that's what you're relying on?
I don't know that he would have had any knowledge of like the ability to file for a writ of error quorum nobis proceedings, but also the time at which he got, or he made his first filing with legal aid was, I think, in like October or November of 2021, might have even been September of 2021. And I don't know whether or not it's a year exactly, but we filed this proceeding in September of 2022. So it's entirely possible that if you judge it, again, I apologize not knowing the dates literally off the top of my head, but if you judge it from the time period of, well, when was he first having legal aid file things on his behalf, to when he filed this petition, I think it might be within the year. But I want to also, before I get too far down the rabbit hole of his mental health, I want to talk too about the attorney abandonment that occurred, because that's a separate prong that can provide for writ of error quorum nobis relief. And I want to accentuate that by the time, well, immediately after his conviction, before sentencing actually, he had an attorney switch. So his public defender was switched out for hired counsel by his family. And the hired counsel filed a motion for a new trial, and then it represented him on direct appeal, and then it represented him on the trial court level of post-conviction proceedings. And as I point out in my brief, an attorney really should review the record of the proceedings for at least one, if not all three of those different filings, right? The motion for a new trial, the appeal, and the petition for post-conviction. And it's evident that this attorney didn't ever review that, because the name of at least one of the alibi witnesses as an alibi witness was specifically referenced in the trial court proceedings. There was another witness who said, I don't know why Michelle, doesn't say Alston, but that's who he's referring to, I don't know why Michelle Alston says that Mr. Darius was at a family barbecue, because He wasn't at no barbecue. I saw him on the Rock Road, right?
I'm a little perplexed at your claim, because within the petition, it says that this witness that you're claiming is newly discovered was known to trial counsel because she was at trial, and you're claiming that this was in fact an alibi when the defendant himself said he was with his girlfriend or some woman the night before, and hear me out. And then he went to the two alibi witnesses. I'm going to let you respond. I know I'm peppering you. but
It's fine.
I have a lot of questions about this case. So he said, at some point in the materials, he said that he was with someone else, not the people who we have affidavits from. And then he went to their house. That's my first issue. Then secondly, didn't we say, based on the proof I think there was a video recording showing the victim in this case alive at 3-something, and which was inconsistent with the defendant's alibi or the purported alibi through another witness. I'm having a problem because your timeline is off, your alibi witnesses are off, so help me understand why, number one, trial counsel somehow was ineffective, and then number two, how post-conviction counsel was somehow ineffective, because your writ of error quorum nobis abandonment claim rings post-conviction, not error quorum nobis.
Right. So I'll start first. I want to outline the timeline, and I'm going to do this based upon the affidavits of the 3 witnesses, because those 3 witnesses, affidavits of 2 witnesses, and then the testimony of a 3rd witness who testified my client was at the barbecue. So there's a Michelle Johnson and a Marvin Johnson, and then a Jacqueline Alston, and those are all 3 related to my client. There was a family barbecue at Michelle and Marvin's house the night before the murders. Michelle and Marvin's affidavit and testimony indicate that they came back to Henning, picked up Mr. Alston because he was getting in trouble, picked him up, took him back to his house, and took him back to their house, and told him he had to stay there the entire night. And that he did then stay there the entire night. He was there the following morning. It doesn't really matter that he stayed there the entire night, because the evidence is that the other person was not killed till 3:38 in the afternoon the following day anyway. But he stayed there the entire night. The following morning, their testimony was he stayed there the entire day until there was phone calls, multiple phone calls that came in saying that the 2 victims had been shot in the cemetery. And that's the first time, according to those 2 witnesses, that my client left the house that day.
But we don't know when the victims were shot. That's what's fatal to your claim. We don't know when the victims in this case were actually shot and killed. It was just sometime, I guess, after.
Has to be after 3:38.
3:38.
Right. And if my client, according to the testimony of these 2 witnesses, and then the 3rd one testified that she arrived at the party around 12 p.m., and that Mr. Alston was there the entire day until the shooting happened, that means that the victims must have been shot while Mr. Alston was at the party. Because if the victims were shot sometime between 3:38 and when the phone calls came in saying the victims had been shot, and Mr. Alston was at the party the entire day, he couldn't have been off somewhere
Was
shooting.
the investigator the one who testified that either the video was inconsistent with an alibi? There was something either in the direct appeal where we concluded that there was not evidence in support of an alibi defense. Can you speak to that at all?
Yeah, I believe in the direct appeal, there is a mistake as to Sammy Haley's testimony
Okay.
that he went, the direct appeal, I believe, states something like that Mr. Haley testified that after seeing the defendant near the scene of the crime, he then went to the barbecue and the defendant wasn't there. That's what I understand from the court's ruling. And that's incorrect on the record. And I could totally,
Okay.
I'm not blaming the court, I could totally
No,
sue.
I just needed.
Yeah, that's incorrect on the record because if you look at the testimony of Sammy Haley from the trial and from the post-conviction, the quorum nobis proceeding, but particularly from the trial, it's clear that he went to a different barbecue. He saw the defendant, no, seriously, he saw the defendant, and he and the people he were with then went to a different barbecue,
Okay.
right? And so it's not the case, and I believe I outlined this clearly in my brief, but it's not the case that the alibi testimony doesn't line up.
All right, now you can tell me why the quorum nobis court is wrong, because they produced a fairly thorough order in this case.
Right.
Denying relief.
Well, I see that my time is up. You want me to finish real quickly?
Yes.
Okay.
I don't mind.
Go right ahead. Go ahead.
Okay, so do you want to focus on the mental health part, or do you want to focus on the?
Focus on what your strongest argument is.
Okay, sure. So I'm going to deal with the effective attorney abandonment. Okay, so you have the initial trial attorney never investigated these witnesses, right? So you have these witnesses, one of which came to him and he still didn't investigate. Putting that to the side, though, because that's all predates the time period that the quorum nobis court looked at in this case. If you start from the time period the quorum nobis started from, which was when the conviction happened, right? At that point, he was being represented by Mr. I forget the gentleman's name. I'm blanking on it now. But at that point, he was being represented by new counsel.
Ferguson.
I'm sorry?
Ferguson.
Yeah, Claiborne Ferguson, thank you. And Mr. Ferguson's firm had 3 different attorneys represent him of the life of the case. They did not meet with him at all until the day of his post-conviction hearing. Did not meet with him one time, until the day of his post-conviction hearing. And then on top of that, despite having 3 different responsibilities where they should have looked at the record, 3 different filings where they should have looked at the record and seen the evidence of the alibi witnesses, they never investigated any alibi witnesses. As post-conviction counsel, it would have been incumbent upon them to not only talk to the client, but also talk to the client about potential alibi witnesses. They never did any of that. So they didn't look at the alibi witnesses under their own independent responsibility to. Then on top of that, they ignored the evidence in the record, which kind of indicates they didn't even really read the record carefully to see what grounds for post-conviction relief he might have. Because the alibi witnesses are right there. Another witness is talking about them during trial.
I get it. Again, if we were on post-conviction, you would have a strong argument. But nothing that you've said is applicable in, petition for error quorum nobis. And I know that your time is out, and I'm going to defer to my colleagues and then allow you to wrap up.
Okay, does either of your honors have any questions? Okay, so I'll wrap up really quickly. In my brief, I explain how the attorney abandonment criteria for equitable tolling, based on what the United States Supreme Court has set out, is different from the ineffective assistance of counsel argument. And so I'm not arguing ineffective assistance of counsel twice, or as the state said, they've tried to claim that I'm arguing ineffective assistance of post-conviction counsel. It's not what I'm arguing. I'm arguing abandonment by post-conviction counsel. There's a different standard for that. I outlined it in my brief.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Davey Douglas on behalf of the state. This court should affirm the dismissal of the quorum nobis petition because it was untimely filed and the petitioner is not entitled to tolling of the statute of limitations. Our Supreme Court recently decided in Clardy versus State that to toll the statute of limitations, there has to be newly discovered evidence of actual innocence. The petitioner does not have that here. This alibi proof is not newly discovered because if it's true, the petitioner has known about it since the day of the shooting.
Is that per se true? So I was trying to look for cases that said if it's an alibi, it's kind of similar to impeachment. It's still grounds, but is it per se just knocks it out of error quorum nobis because the petitioner himself should have known that he had an alibi?
I think it kind of is, Your Honor. I mean, again, this is to be newly discovered evidence must be of facts existing but not yet ascertained at the time of trial. And if there's an alibi defense, it's always necessarily ascertained by the petitioner at the time of trial. I mean, he could have told trial counsel about these two witnesses. He could have told trial counsel that he spent the night with them. Instead, he didn't mention their names and said that he spent the night with a woman before the day of the shooting. It would be the state's position that, yes, he's foreclosed here by the fact that he's known about this since the day of the shooting.
And these alibi witnesses were family members?
They were.
And one of them, or at least one of them, approached trial counsel about it?
She testified that she tried to. She was it wasn't entirely clear the steps that she did take. She testified about how I think she showed up on the first or second day of trial and maybe tried to make contact with trial counsel there. And I think she made a phone call to trial counsel's office. That's what she testified to.
When he was represented by public defender's office.
Yes, Your Honor. But again, this witness may have taken steps to try and contact trial counsel, but that doesn't erase the fact that the petitioner would have known about these witnesses and didn't tell trial counsel about them. And because he hasn't presented any newly discovered evidence of actual innocence, that's where the inquiry should end. There's no need for this court to reach the issues of whether mental incompetence told the statute of limitations or whether attorney abandonment told the statute of limitations. But even if this court does want to consider those issues, neither one entitles the petitioner to tolling here. The mental incompetence argument is wholly undercut by the fact that the petitioner was filing notices of appeal pro se, and that he was filing motions to waive the timely notice of appeal requirement pro se during the time he claimed that he was incompetent. And the Coram Nobis Court properly relied heavily on those pleadings to show that he understood his rights and he was able to make a rational choice amongst those options. And then turning to the issue of attorney abandonment, there's absolutely no abandonment here because counsel filed a motion for a new trial. Counsel filed a notice of appeal, filed a brief, represented him during the post-conviction proceedings. This is far from the extraordinary case where an attorney essentially just withdraws without saying anything to a client and then causes them to miss important deadlines. That's not what happened here. Really, what this is a claim of ineffective assistance of post-conviction counsel or ineffective assistance of trial counsel, which this court has said is not cognizable in a Coram Nobis proceeding and is insufficient to toll the statute of limitations.
So with all that being said, what was intriguing to me about this record is that the post-conviction court granted relief for the co-defendant and on the grounds of an alibi witness. Can you speak to me about that issue? Was it the same post-conviction court, an Coram Nobis court that we have in this case?
I think they were different.
Okay.
I think they were different, and to the extent that there was post-conviction relief granted for the co-defendant, I believe it was because counsel was apparently ineffective for failing to investigate a potential alibi witness. But it really has no bearing on Mr. Alston's case because there's no allegation that he and the co-defendant were ever together at the...
I thought the co-defendant implicated Mr. Alston.
Or sorry, that they had the same alibi. The co-defendant's claim was not that he was at the barbecue at the Johnson's house with Mr. Alston. So there may have been a different alibi defense that the co-defendant's attorney was ineffective for failing to pursue, but it doesn't affect Mr. Alston's claim here. And so the fact that the co-defendant got post-conviction relief would not be a basis for this court to toll the statute of limitations or to allow this.
I was just curious as to how that happened or unfolded.
But that's, to my understanding, that's what happened. And unless there are any further questions from this court, we would ask this court to affirm the judgment of the Quorum Nobis Court. Thank you.
Thank you, General.
I just want to respond real quickly to Judge McMullen's question that she asked of my opposing counsel regarding the different courts here. So my client had his post-conviction case heard by one trial judge in Lauderdale County. I believe that trial judge retired. Then Judge Neal was appointed or took office. I don't know whether he was appointed or elected, but he became the judge in Lauderdale County. And Judge Neal heard the post-conviction hearing for the co-defendant, which was based on failure to qualify witnesses, found in favor of the co-defendant, vacated his conviction for a new trial. And then kind of while all that was occurring, I don't remember the exact order of events, but it was after my client's post-conviction claim had failed, but also in front of Judge Neal, we filed the petition for writ of error quorum nobis relief. And Judge Neal denied that on the procedural grounds here. So it was the same judge for co-defendant's post-conviction and my client's
Error quorum.
error quorum nobis, but a different judge between my client's error quorum nobis and my client's post-conviction. I also wanted to address the issue of legal aid assisting my client with filing the pro se filings. So I wrote in my brief, as to Mr. Alston's pro se filings occurring on August 3rd, 2021 and January 5th, 2022, the record indicates they were accomplished with substantial help of legal aid at the prison where he was housed.
But we don't have any, this is not federal court, where they give some weight to assistance from prison lawyers or law clerks. We don't have any cases that distinguish between whether you get aid with someone from the prison or the law library or anything like that. So I just want to make that, I want you to recognize that. I understand that his pleadings were with the assistance.
Yeah.
We don't distinguish.
I just wanted to make clear that what I said before, well, what I was guessing at, honestly, and I said that before, it was not entirely accurate.
I got you.
Because I think that the pleadings reflect that he filed something in August of 2021, and then in September of 2022 is when we filed the petition for post-conviction relief. But I think I outlined sufficiently in my brief, so I won't go into it here, why even in light of that, he should still be entitled to equitable tolling. I want to make one other thing clear before I wrap up, and that's kind of what the underlying argument of this case is. So, and I want to distinguish it from claiming ineffective assistance of counsel twice over, as I mentioned before. So, if you have a situation where your trial counsel is told about alibi witnesses, but trial counsel doesn't call them, and those alibi witnesses could exonerate you, right? That is obviously something that your post-conviction counsel, if all those things are true, should take up in post-conviction, right? But what if your post-conviction counsel doesn't, right? Well, this court has held, and I believe the Supreme Court has held too, well, there's no constitutional right to effective assistance of post-conviction counsel, right? And that's true as far as the law goes. There is no constitutional right. However, when it comes to due process tolling, 14th Amendment due process tolling, the Supreme Court has outlined situations in which, the Supreme Court of the United States, and then adopted by our Supreme Court, has outlined situations in which attorney abandonment can lead to due process tolling. And the standard, as I mentioned before, is different for attorney abandonment. It's actually a stricter standard than ineffective assistance of counsel. And so I'm not arguing ineffective assistance of counsel twice over. What I'm arguing is maybe that his first attorney might have been ineffective, might have even risen to the level of abandonment. But if you then look at what happened with his post-conviction counsel, they effectively abandoned him.
But none of the cases that we have that represent the principle that you've just articulated, they don't stand for that proposition. In this case, post-conviction counsel represented the defendant, conducted a hearing, filed briefs, sent a letter saying, hey, this is done, we're no longer representing you. The cases that stand for attorney abandonment involve lying to, an individual. And I know your time is up, so I'm not gonna, I know your brief is well done, and I really want to applaud you for taking the case pro bono. The court really appreciates the work that you've done on this. But as you wrap up, please address the per se alibi not being newly discovered because the defendant should have known, because it was his, he knew who he was with, and then address that in the context of the Supreme Court's most recent case, Clarity.
Right. So I'll start first with Clarity, because I thought about that before we came in. I don't think that Clarity is applicable here, because the Clarity case is really about what level of proof is required to show actual innocence, not whether the evidence newly discovered.
You don't think Clarity applies here when you're trying to get equitable tolling?
I think yes, that applies, but I think that the issue decided in Clarity is very different from the issue to be decided in this case, because in Clarity, there was an affidavit filed by a witness saying, I've never met the defendant, right? But that affidavit didn't in any way show that the defendant was actually innocent. And so what Clarity decided is, if you just have an affidavit saying, well, the defendant might be innocent, and we should have a hearing on it, it doesn't say he's actually innocent, well, that's not enough to equitably toll. In this case, we have affidavits saying the defendant is actually innocent, and so therefore we meet the Clarity standard on that point. Now, as for the question of whether or not he should have known about it, right? It's hard for me to imagine what is going on in the head of a person who is a documented paranoid schizophrenic at the time of trial. He was already documented as having that, or severe mental illness, I believe was the way the court phrased it, but the court put that in an order. So he has, severe mental illness or enough for the court to order an evaluation, and his trial counsel, I don't know to what context they had those conversations, but no one ever actually talked to these witnesses until I did. Not one person talked to them. I think that's what makes it newly discovered evidence, is that, we have a witness, we have a defendant that is suffering from severe mental illness. We have lawyers that didn't do their job. And when you look at equitable principles, that should allow my client to come in and get due process tolling for equitable relief. Thank you.
All right, thank you. And we second Judge McMullen's remarks. We appreciate your work on the case and the excellent brief.
Thank you.
Thank you. All right, I believe that completes our docket.
Yes, Your Honor.
All right, we'll be at recess till the August docket.